I republished the American Slave Code in exact accordance to this 1853 publication, without adding or omitting a word. So when you purchase the book, it keeps it around for another 100 years simply because everybody that has a book, somebody is going to come across it 100 years from now and they'll have it, just as I did. Uses of slave property. Slaves as property may be used absolutely by their owners at will, for their own profit or pleasure. Property is that which may be used by the owner. The slave is one who is in the power of a master to whom he belongs. Goods they are, and as goods they are esteemed. This is the law of the relation. As goods, therefore, they may be used, while, like other goods, they perish with the using. Have I not a right to do what I will with mine own? Is a question affirming a prerogative universally claimed. Admit the validity of the ownership, and the right of use follows of course. If the legal relation be an innocent one, the right of use and the exercise of that right are innocent likewise, provided the use be a legitimate one. We shall see what uses are deemed legitimate by those who have shaped, defined, and administered the relation. It is true that the use of property by the owner is limited by the rights of other persons. But slaves are not persons in the view of the law, for any purposes of benefit to them, as will hereafter be more fully shown. The rights of a slave are not recognized, and no limitation of the master's use of him can come from that quarter. The slave, says the law, is entirely subject to the will of his master. Nothing, therefore, can prevent the master from putting him to any use he pleases. It is also true that the use of property by the owner is limited by the nature of that property. Thus, a living horse or other domestic animal may not lawfully be hacked and hewed to pieces, as a block of wood may be. The barbarity may be punished. The most that can be claimed for the slave code on this point is that by placing slaves upon a level with other live cattle, it entitles them to the same kind and degree of protection. Beyond this, the slave code, so far as we know, never attempts or pretends to protect them. It knows them only as mere animals. Their rational and moral natures, not being recognized by the laws, can claim no legal protection. Sufficient evidence of this has already been adduced, but it will accumulate as we proceed, and it will be seen that as a mere animal, the slave has not equal protection in some respects with other animals. We will specify some of the uses of slave property. A prominent use of slave property is unrequited slave labor. The hired laborer is employed. The slave laborer is used as a horse or an ox is used. His labor is held to be the property of his owner. At this point he is degraded to the level of a brute. Whether moderately or excessively worked, the use of a slave as a brute laborer is an injury and an insult. It is a denial of his nature as a man, and of his rights as a free moral agent. The end of slavery, said Judge Ruffin, is the profit of the master. The slave is doomed to toil that others may reap the fruits. State versus Man. North Carolina Reports, page 263. Wheeler's Law of Slavery, page 246. This honest judicial decision should shame the pretense that slaves are held for their own benefit. In a separate chapter, we shall look more directly into the particulars of slave labor, and in another shall consider the withholding of wages. Additional light will be thrown upon this use of slave property. In the meantime, it will be easy to show that in this use of slave property in some of the slave states, it is systematically and deliberately so used as to be used up and destroyed in a manner that would be shameful and wicked. even if brute beasts were the victims. Dr. Deming, a gentleman of high respectability residing in Ashland, Richland County, Ohio, stated of Professor Wright at New York City that during a recent tour at the South, while ascending the Ohio River on the steamboat Fame, he had an opportunity of conversing with a Mr. Dickinson, a resident of Pittsburgh, in company with a number of cotton planters and slave dealers from Louisiana, Alabama, and Mississippi. Mr. Dickinson stated as a fact that the sugar planters upon the sugar coast in Louisiana had ascertained that, as it was usually necessary to employ about twice the amount of labor during the boiling season that was required during the season of raising, they could, by excessive driving, day and night, during the boiling season, accomplish the whole labor with one set of hands. By pursuing this plan, they could afford to sacrifice one set of hands once in 7 years. He further stated that this horrible system was now practiced to a considerable extent. The correctness of this statement was substantially admitted by the slaveholders then on board. Wells, Slavery as It Is, page 39. The late Mr. Samuel Blackwell, a highly respected citizen of Jersey City, opposite the city of New York, and a member of the Presbyterian Church, visited many of the sugar plantations in Louisiana, and says that the planters generally declared to him that they were obliged so to overwork their slaves during the sugar-making season, from 8 to 10 weeks, as to use them up in 7 or 8 years. For, said they, after the process is commenced, it must be pushed without cessation, day and night, and we cannot afford to keep a sufficient number of slaves to do the extra work at the time of sugar making, as we could not profitably employ them the rest of the year. Wells, Slavery as It Is, page 39. Reverend Dr. Reed of London, who went through Kentucky, Virginia, and Maryland in the summer of 1834, gives the following testimony. I was told, confidentially, from excellent authority, that recently, at a meeting of planters in South Carolina, the question was seriously discussed whether the slave is more profitable to the owner, if well fed, well clothed, and worked lightly, or if made the most of at once, and exhausted in some 8 years. The decision was in favor of the last alternative. That decision will, perhaps, make many shudder. But to my mind, this is not the chief evil. The greater and principal evil is considering the slave as property. If he is only property, and my property, then I seem to have some right to ask how I may make that property most available. Visit to the American Churches by Drs. Reed and Matheson, Volume 2, page 173. Other testimony might be added. Southern newspapers have published the proceedings of agricultural societies, in which, after discussion, it had been agreed that the more profitable method was to use up a gang of Negroes once in 7 or 8 years, and then purchase a fresh supply of the dealers. A terrible sacrifice of life arises from a change of climate. A writer in the New Orleans Argus of 1830 says, "The loss by death, in bringing slaves from a northern climate, which our planters are under the necessity of doing, is not less than 25%. Advertisements like the following are not uncommon. I offer my plantation for sale. Also, 20 fine acclimated Negroes. O.B. Cobb, Vicksburg Register, December 27, 1838. I will sell my Old River plantation, near Columbia, in Arkansas. Also 130 acclimated Negroes. Ben Hughes, Port Gibson, 14th January. Probate sale. Will be offered for sale, at public auction, to the highest bidder. 130 acclimated Negroes. G.W. Keaton, Judge of the Parish of Concordia, Louisiana. March 22, 1837. General Felix Houston advertises in the Natchez Courier, April 6, 1838. 30 very fine acclimated Negroes. C.J.'s View, pages 98 and 99. Dr. Reed was correct in charging the murderous use of slave property to the principle or law of slave ownership, which constitutes what is called the legal relation. Such treatment may be called an abuse, but is a result which will be almost certain to follow, where laborers can be owned and used, instead of being bargained with and hired. Even on the low ground of consequences, such a relation is to be condemned. Another prominent use of slave property, in the case of females capable of being mothers, is that of breeders of slaves. And if the tenure of slave property be legitimate, and the ownership valid, by what rule of law or of logic shall this use of slave property be condemned? The argument of Mr. Golson of Virginia on that assumption holds good. See Chapter 2. If the owners of lands, of orchids, and of brood mares had a right to their products, why had he not a right to the products of the slave woman he had purchased? Had not the slave code, the legislatures and the courts secured to him his claim upon them as chattels personal, to all intents, constructions, and purposes whatsoever? Might he not, with other great statesmen, footnote, Henry Clay, Speech in the United States Senate, 1839, affirm that is property which the law declares to be property, and that 200 years of legislation have sanctified and sanctioned Negro slaves as property? Did he not sustain to those women the relation of owner, and had not doctors of divinity, Northern and Southern, attested the lawfulness and the innocency of sustaining the relation? And how could there be a relation without its implied rights? Thus fortified, was not his inference warranted by his premises when he spoke as follows? We quote again from his speech. The legal maxim of partis sequitur ventrum is covial with the existence of the rights of property, and is founded in wisdom and justice. It is on the justice and inviolability of this maxim that the master forgoes the service of his female slave, has her nursed and tended during the period of her gestation, and raises the helpless and infant offspring. The value of the property justifies the expense, and I do not hesitate to say that in its increase consists much of our wealth. Speech and Legislature of Virginia. The closing sentence indicates the extent and importance of this use of slave property. According to the estimate of Henry Clay as before cited, Chapter 2, this use, to raise slaves for the Southern market, is of more pecuniary value to the farming portion of the slave states than all their agricultural operations. The value, indeed, cannot fall short of the receipts for exports of surplus slaves to the South. Professor Dew, afterwards president of William and Mary University, Virginia, speaking of the slave trade from Virginia, said, "It furnishes every inducement to the master to attend to his Negroes, to encourage breeding, and to cause the greatest number of slaves to be raised, etc. Virginia is, indeed, a Negro-raising state for other states, to which may be added the far-famed announcement, 'The noblest blood of Virginia runs in the veins of slaves.'" In the Charleston Mercury, the leading political paper of South Carolina, appeared the following advertisement: "Negroes for sale. A girl, about 20 years of age, raised in Virginia, and her 2 female children, one 4 and the other 2 years old, is remarkably strong and healthy, never having had a day's sickness, with the exception of the smallpox in her life. The children are fine and healthy. She is very prolific in her generating qualities, and affords a rare opportunity to any person who wishes to raise a family of healthy servants for their own use. Any person wishing to purchase will please leave their address at the Mercury office." The coarseness of this language disgusts us, and so does the language of Mr. Golson. But the facts involved differ nothing from the statements of Henry Clay, as quoted in our chapter on the traffic in slaves. And whoever will take up and study the judicial decisions cited in Wheeler's Law of Slavery concerning the increase of slaves will find that the newspaper advertisements of which we have furnished a specimen are merely descriptive of a business recognized and protected as respectable in courts of justice. And this remark will be found to apply not merely to the supply raised for the interstate slave trade. The litigation reported in Mr. Wheeler's book under the head of increase of slaves is mainly that which grew out of neighborhood transactions and the inheritance of slave property. And we have already, in discussing the nature of slave ownership, Chapter 1, taken occasion to quote from Mr. Wheeler's Law of Slavery, page 325, the express language of the judges placing the issue of female slaves, when hired out for 5 years, upon the same footing, and to be awarded upon the same rules, as in the case of the increase of brood mares, or other female animals. Another use of slave property, sometimes probably connected with the preceding, is indicated by advertisements of beautiful young mulatto girls for sale, and by the fact that these commonly command higher prices than the ablest male laborers, or any other description of slaves. A reputed daughter of Thomas Jefferson was said to have been sold at auction in New Orleans for $1,000. Many have been sold for $2,000. One young woman was sold at public auction to a rich young planter for $7,500. It must be an able field hand that commands $800. Forced marriages of slaves with slaves, including second and third marriages after separations from former companions by sale, constitute a class of well-attested facts. The Savannah River Baptist Association decided that in case of such separation of Baptist slave husbands and wives, it was lawful for them, without church censor, to form such new connections in obedience to their masters, whose right to enforce such arrangements was thus tacitly acknowledged. Forced concubinage of slave women with their masters and overseers, often coerced by the lash, constitutes another class of facts equally undeniable. Bides Wells, Slavery as It Is, page 15. Committed on a female slave is an offense not recognized by law. Manuscript by Judge J. Such facts, in their almost interminable varieties, corroborate the preceding, and illustrate the almost innumerable uses of slave property. Another use of slave property, and a very remarkable one, assures us that the Southern owners of this peculiar kind of property have ways of turning it to account that even Northern ingenuity could scarcely have devised, unless, indeed, it be a Yankee's invention. Assortment of diseased, damaged, and disabled Negroes, deemed incurable and otherwise worthless, are bought up, it seems, cheap, no doubt, like old iron, by medical institutions, to be experimented and operated upon for purposes of medical education and the interest of medical science. The Charleston, South Carolina Mercury, October 12, 1838, contained an advertisement by Dr. T. Stillman on behalf of the medical infirmary, setting forth its objects and closing as follows. To planters and others, wanted 50 Negroes, any person having sick Negroes considered incurable by their respective physicians and wishing to dispose of them. Dr. S. will pay cash for Negroes affected with scrofula or King's evil, confirmed hypochondriasm, apoplexy, diseases of the liver, kidneys, spleen, stomach and intestines, bladder and its appendages, diarrhea, dysentery, etc. The highest cash price will be paid on application as above, namely Medical Infirmary, number 110 Church Street, Charleston. It seems indeed difficult to foresee or imagine all the uses to which slave property may be put by the owner. The slave is entirely subject to the will of his master. He is supposed to have no conscience and no rights. What his owner commands him to do, he must do. What he requires him to be, he must be. What he chooses to inflict upon him, he must suffer. He must never lift a hand in self-defense. He must utter no word of remonstrance. He has no protection and no redress. This will more fully be shown as we proceed. The slave, however pious, and whatever his scruples, must do the work allotted to him. It may be the drudgery of a tippling shop, a gambling house, a brothel, or a den of counterfeiters or shoplifters. And he must witness in silence whatever he sees there, if it be a murder. He cannot testify against a white man. He is merely property to be used. A class of murderers of slaves by slave masters may as well be put down in this category. The Munster Lilburn Lewis, nephew of Thomas Jefferson, who chopped in pieces a living article of slave property in presence of his other slaves, only used up that article to all the others into subjection, as he told them. But this was an abuse of the relation, a violation of the law. Perhaps it was. In words, the law prohibits the murder of slaves. How much it intends or affects will be seen in another chapter. A slaveholder flogged a little slave girl and put her feet in the stocks. She was found dead. A prominent lawyer of a respectable family was asked whether the murderer of this little helpless child could not be indicted. He coolly replied that the slave was Mr. P's property, and if he chose to suffer the loss, no one else had anything to do with it. Bideswell's Slavery as It Is, page 54. The slave child was property and had only been used. It is believed that no record exists of a white man having been executed in the United States simply for the murder of a slave. Manuscript by Judge J. In another chapter, this point will be examined. Again, we find the people to be no better than their laws. If these practices are to be considered unauthorized abuses, the people are worse than their laws, for they are practiced with impunity. If you would like to purchase the American Slave Code, you may do so by visiting the description area under this video. Click the link to the baby book patch. There you will be routed to this book. I thank viewers in advance for the purchase of the American Slave Code, as your purchases greatly support this channel and the intense work involved in the republishing of history by first-hand eyewitness account.